Hi everyone. In today's lecture, we will be reviewing Chapter 12. Chapter 12 is all about risk management, quality management, and utilization management. As many of you already are aware, quality management is very near and dear to my heart, given that I came from a quality management background prior to coming to work with Suffolk Community College. So I'm excited to talk about this chapter, and we'll go ahead and get started. Okay, so to give you a brief introduction, most legal issues that concern health information management focuses on patient-specific health information that's given and obtained during the course of normal patient care. The focus of our textbook and lectures have really centered on health information that's contained in patient health records. Majority of a health information manager or director's practice focuses on such information. There is practice that focus is not exclusively on this. Health information management practices also are responsible for addressing non-patient records. So, two non-patient record areas in which health information professionals play a key role are risk management and quality management. Both are methods of quality control that exist in virtually every hospital and healthcare facility. Both are distinct, they improve techniques. The extent to which they are integrated vary, though, from organization to organization. In this chapter, we will review an all-encompassing look at risk management and quality management, and it will concentrate on the legal bases and requirements for these two programs. Closely related to quality and management is utilization management. Now, utilization management is an activity that requires the focus on both the health record and non-patient records. So we'll discuss in detail the evolution of utilization management and the utilization review process. So risk management, what it is it's a non-clinical function that focuses on how to reduce medical, financial, and legal risk to an organization. This reduction is tied directly to risk. Now, risk estimates the probability of loss from a given event upon operations or financial performance of an organization. Understanding that the universe of probable events, the strategies employed to mitigate and minimize the effects of each of these events, and how to contain negative consequences is central to managing risk. As a general matter, risk management is designed to achieve two key purposes. The first is to identify areas of operational and financial risk or loss to the healthcare organization, its patients, visitors, and employees. The second is to implement measures to lessen the effects of unavoidable risks and losses, prevent reoccurrences of risks or losses, and cover inevitable losses at the lowest cost. A risk management program is very outcome-oriented. It focuses on potential risks to the healthcare facility and the methods that are used to avoid those risks. The growth and development of risk management in the healthcare field can be traced to several different influencers, among them the loss of the doctrine of charitable immunity. For most of the century, healthcare institutions were shielded from liability for the negligent acts of their employees by the doctrine of charitable immunity. Beginning in the 1960s, this doctrine was slowly dismantled through court decisions. Without the protection afforded by charitable immunity doctrine, healthcare organizations became exposed to an increasing number of lawsuits that were brought against them. The growth of risk management was also assisted by several other forces. The first is medical malpractice crisis of the 1970s. We also will discuss the Joint Commission and how they began to require hospitals to implement risk management programs within their organizations. And finally, state legislations became involved establishing the statute minimum requirements for risk management programs in hospitals, or delegating that task to administrative agencies. All of these forces converged on healthcare organizations, and executives realized that the risk management principles already in use in business community could be applied to the healthcare community as well. The risk management functions vary from healthcare organization to organization. It may be reported in finance terms, operations, or safety principles. Often, the risk management department works closely with their in-house legal counsel. In HIM managers and directors play a role in a risk management program in at least two ways. The first is through the traditional method of enforcing patient record requirements, and the second is through the use of incident reports. HIM professionals have traditionally influenced risk management processes by implementing, enforcing, and educating healthcare providers about the patient record requirements. This education role centers on three main areas, which includes documentation, security, and confidentiality. HIM professionals cannot stress too heavily the importance of proper documentation in order to reduce risks. The health record serves as the legal requirement of a particular episode of a patient's care. It's the backbone of every professional liability action. As such, it is used to prove what did or did not happen in a particular case, and it tries to establish whether the applicable standard of care was met. A properly documented health record benefits a healthcare provider's defense in a lawsuit. A poorly documented health record hinders the healthcare provider's defense. A properly documented health record includes both timely, complete information, and it means that all entries in the record are authored and authenticated and reflect the total care that was actually rendered to the patient. With proper documentation, the risks to a healthcare facility may be reduced in several different ways. The security of health information falls within the role of health information managers and directors. Security issues regarding a risk management program have traditionally centered on the availability of health records for purposes of patient care, access to patient-specific health information by or on behalf of the patient, and the retention of health records. New issues related to database management and electronic health records have emerged that have added complexity to the security issues. The ready availability of a health record to a healthcare personnel cannot be understated. Various medical disciplines use this health record as a method to communicate about the patient's illness and course of treatment during a particular episode of patient care. This should the patient subsequently require care, healthcare providers rely on information from prior health records to assist in the diagnosis and treatment of the patient. Failure to make health records available during a current or subsequent episode of patient care may result in harm to the patient and exposure of the healthcare provider to liability. Availability of health records involves the question of access to health information by or on behalf of the patient. It questions access that are governed by a complex web of laws and regulations that we have addressed in detail in the prior Chapter 10. Because of the complexity, requests for access to patient-specific health information should be handled only by those with proper training and supervision. Availability of health records also involves the question of how long health records should be retained. At minimum, healthcare facilities reduce the risk of a lawsuit for negligent loss of records by retaining records for the minimum period that's specified under statute and regulations. Risk management also intersects with database management concerning that clinical data stores in automated systems such as the electronic health record. The Security Management Process Standards issued pursuant to the HIPAA, the security rule, requires that a covered entity perform a risk analysis to determine security risks and implement standards to reduce risks and vulnerabilities to electronically protected health information, known as EPHI. Such security risks may include breaches to confidentiality, integrity, and availability of EPHI. The standards of the security rule do not specify the approach for this analysis, nor does it specify the types of security measures that should be implemented. This allows for the flexibility by the covered entity. However, guidance is provided through papers published on the CMS website. The standards do require that the covered entity document its efforts and maintain this documentation for at least 6 years and provide review and modifications of efforts on a regular basis. A matter that is closely associated with health information management professionals is confidentiality. Confidentiality is central to reducing risk. Confidentiality, as a reminder, is the obligation of the healthcare provider to maintain patient information in a manner that will not permit dissemination beyond the healthcare provider. The healthcare community has for decades considered the confidentiality of health information a matter of the utmost importance, and failure of providers to respect confidentiality combined with a greater public awareness of the adverse effects of unauthorized disclosure of health information may have an impact on risk management programs through an increased number of lawsuits. Lawsuits generally allege violations of the right to privacy, breach of confidentiality, and/or the breach of contract. Risks of such lawsuits may be lessened through education of healthcare professionals concerning the professional and legal obligations to maintain confidentiality. Beyond education, healthcare organization may reduce the risk by adhering to and enforcing its policies regarding the confidentiality of patient information. Proper documentation in the health record includes recording adverse incidents that occur during an episode of patient care. Such documentation in the health record is separate and distinct from an incident report, which is a risk management technique used to describe and manage an adverse incident. Understanding the difference is essential to the proper functioning of a risk management program. To describe an incident report accurately, the learner first must understand what an incident is. A hospital incident is defined as any event or circumstance not consistent with the normal routine operations of the hospital and its staff or the routine care of a patient. It may be an error, an accident, or a situation which could have or has resulted in injury to a person or damage to hospital equipment or property. Incidents may encompass a variety of events, such as medication error, a slip, a fall, loss of a patient's belonging, or an equipment malfunctioning affecting the patient. The incident is not limited to patients alone, but may also affect healthcare providers, employees, or even visitors. Because the incident is not routine and could or did result in injury to a person or damage to equipment and property, it is considered adverse. Incident reports is the documentation of the adverse incident, whether it's done on paper form or through a computerized database with access that's highly controlled. The report in detail describes the incident itself, including the time, date, place of occurrence, along with the condition of the subject of the incident, patient, employee, visitor, statements or observations of witnesses, and any responsive action taken by healthcare providers or the organization. The report is different from the health record in that if poorly developed, it may also include subjective statements or opinions that concerning fault or the circumstances surrounding the incident. The health record, on the other hand, consists of a basic recounting of facts devoid of personal opinion or subjective statements. The incident report should be filed separately from the health record. An incident report serves multiple purposes. It documents fully the circumstances that surround the incident. It documents and identifies the situations that may lead to litigation, and it educates healthcare personnel in order to prevent future incidents and create a database for monitoring the number and types of incidences. The first two purposes relate to the traditional notion of risk management because they serve to alert the provider's attorney and insurance carrier to specific incidences that may lead to a claim against that provider. The second two purposes relate not only to risk management, but also to quality assurance. In addition, it identifies specific incidences of risks. Incident reports also permit the provider to study patterns of activity to determine which practices should be altered and how to fashion training programs to achieve the optimum result. These multiple purposes are best served if the incident report is completed as soon as practicable after the incident when memories are fresh. By completing the report in a timely fashion, the provider hastens the availability of the report to its attorney, insurance carrier, and quality assurance department for a review and evaluation. It is then that the availability of the report to the provider's attorney will determine whether the report is discoverable and admissible in the event of litigation. The incident report is an integral component of any loss prevention program. Because an incident report details an event that caused injury to a patient, employee, or visitor, it is one of the most important sources of information to parties involved in a lawsuit against a healthcare provider. Whether the report becomes available to the plaintiff will be determined by the rules of evidence that governs the discovery and admissibility and privileges that attach these rules. Discovery is the process used by parties to obtain information that relates to the subject matter of a lawsuit or an administrative agency proceedings. Admissibility looks at whether information can be entered into evidence at trial. Privilege is the legal right to keep certain information confidential. The attorney-client privilege protects communications that are made between attorneys and their clients from disclosure to third parties. It's designed to facilitate open communication between attorneys and their clients by assuring clients that the communication will remain confidential. This falls within the privilege. Certain criteria must be met. An attorney-client relationship must first be established, and the client must make the communication in confidence for the purpose of obtaining legal advice from the attorney. Whether an incident report will be protected by the attorney-client privilege generally centers on the question of whether a report was made for the benefit of the attorney alone or whether dissemination of the report to others, such as the insurance carrier or internal quality assurance department, will defeat the privilege. Where incident reports do fall under the category of attorney-client privilege and are produced by healthcare providers as part of the discovery process, the recipient of the incident report will claim that the healthcare provider has waived any privilege to protect the document. If the disclosure was inadvertent, the provider took reasonable steps to prevent disclosure, and the provider promptly took reasonable steps to rectify the error, Federal Rule of Evidence 502 would apply to protect the inadvertently disclosed incident report. Overall, health information professionals must understand the applicable rules of discovery, admission of evidence, and the attorney-client privilege within the healthcare provider's jurisdiction, whether or not the HIM professional is formally involved in the healthcare provider's risk management program or not. Traditionally speaking, risk management dealt with assessing patient outcomes and events, writing incident reports, and reviewing past events to determine the need for changes in policy and procedure. Risk management still uses these processes, but now it includes more focus on database management, primarily in two areas. The areas that use data in an automated fashion to measure a healthcare institution's risk, and identifying the risk that's inherent with databases that contain enormous amounts of sensitive data. Automated databases can be powerful tools in risk management. A database is a structured collection of data on multiple entries and their relationship, often arranged for ease and speed of retrieval. As such, it's an ideal method for storing risk management data. Risk management has grown to include areas that have not traditionally been considered within its scope. Occurrences that organizations often require to be reported to the risk manager, such as falls, lost property, IV complications, mislabeled specimens, and against medical advice discharges. Management of these types of occurrences is integral to an effective loss prevention program. Risk management also involves claims management. Risk management managers often act as a liaison to a healthcare organization's attorneys. They may include conducting record reviews. This may include conducting record reviews, arranging depositions, and providing the necessary documentation for claims investigation. The risk manager may also participate in interviews with professional and other staff related to adverse occurrences. Another part of an effective risk management program is Sentinel Event Review. Sentinel event is an unexpected occurrence that involves death or serious physical or psychological injury or other risk thereof. Serious injury includes loss of a limb or limb function. The standards that relate specifically to the management of sentinel events are found in the Improving Organization Performance section of the Joint Commission Accreditation Manuals. Organizations are required to establish mechanisms to identify, report, and manage these events. Organizations also are required to conduct a root cause analysis, referred to as RCA, to identify the cause of the event and should include a clinical as well as an administrative review. Facilities are encouraged but not required to report sentinel events to the Joint Commission within 45 days of the event. If the facility chooses not to report the event and a family member makes the Joint Commission aware, or the Joint Commission becomes aware as other means, the Joint Commission will then communicate to the healthcare facility the requirement to submit the findings of a root cause analysis and action plan. Enterprise risk management refers to the function of analyzing and evaluating all of the risks that confront an organization. It's not just the legal, financial, and medical risks that are traditionally considered. These risks are listed in Table 12.2 in the textbook entitled Enterprise Risk Management Concerns. In combination, it determines how they affect a healthcare organization's strategic plan and overall health. Enterprise risk management considers risks in the context of the opportunities that they may present, with the goal of exploring how those risks may be exploited in order to gain a competitive advantage. A feature central to enterprise risk management is the focus on interrelationships and interdependencies. It's important to determine how a combination of risks affect an organization. Now, the second area that we're going to discuss, in which the health information managers and directors play a vital role concerning non-patient records, is quality management. So quality management has been a long part of the health information professional's role in the healthcare delivery system. Okay. Quality management includes performance improvement, continuous quality improvement, total quality management, quality control, quality review, and problem detection. While each of these terms or methods differ from the one preceding it, it all falls within an umbrella of quality management. Quality management is an improvement technique that healthcare providers use. Quality management is a clinical function that focuses on how to improve patient care. It looks at patterns of activities to define the optimum performance and determine how to achieve it. As such, quality management is primarily process-oriented rather than outcome-oriented. Quality management activities in healthcare organizations are conducted under the control and direction of peer review committees. These committees are composed of healthcare professionals who are charged with the responsibility for evaluating, maintaining, and/or monitoring the quality and utilization of healthcare services. An effective quality management program benefits a healthcare organization by allowing neutral evaluators the opportunity to provide useful feedback and recommendations designed to improve patient care. To achieve this benefit, committee members must fully participate and offer candid criticism of the information that they review. State legislatures have passed peer review statutes. The aim of these statutes are twofold: to protect the deliberations and records of peer review committees from access by non-participants, and to protect participants in peer review activities from civil liability. Not all statutes address both aims. However, most statutes address the first aim. Under the first aim, peer review, deliberations, and records are considered privileged. That is, that protected from subpoena, discovery, or introduction into evidence. Under the second aim, participants are considered immune from monetary liability in the event of a lawsuit or other legal proceeding. Peer review privileges are a matter of state statute. The protections they afford necessarily vary from state to state. Many of the statutes that have been passed in the 1970s protected only peer review activity that took place in hospitals. As new entities, such as health maintenance organizations, became involved in healthcare, peer review statutes were revised to afford these entities the same protections that were afforded to hospitals. State statutes also vary regarding the definition of peer review activity. Some statutes do not define the term beyond general language, such as records and proceedings. Other statutes explicitly state which documents and materials fall within their protections. The statutes further vary by the nature of civil immunity afforded to participants. Some statutes provide absolute immunity from all suits, while others provide only qualified immunity if a defamation action is brought. Where immunity is granted, the law assumes that the participant acted in good faith. If a plaintiff can demonstrate that a participant acted with malice, the participant is no longer shielded from liability. In 1986, the Healthcare Quality Improvement Act was passed, and it was designed to improve the exchange of information about decisions as it relates to the professional competence and conduct of physicians, dentists, and other healthcare practitioners. The desired result of such an exchange of information is an improvement in the quality of medical care through restrictions on the ability of certain physicians and dentists to change locations without disclosing previous incompetent performance or misconduct. The Act accomplishes this result through the use of a national practitioner data bank and complex reporting and query requirements. Information concerning professional competence and conduct is reported to the National Practitioner Data Bank, the NPDB. This is important, guys. I have seen this up on the RHIT exam, so I would definitely highlight this and know what the National Practitioner Data Bank is. With that said, so the National Practitioner Data Bank is held by hospitals, medical societies, licensing boards, prepaid medical practices, and other healthcare entities that are involved in peer review activities. The special information that's contained in the data bank includes data that concerns malpractice payments, licensure actions, and adverse actions such as the loss of staff privileges of physicians and dentists in all 50 states. With this data available in the data bank, healthcare entities such as hospitals or healthcare private practices are now required to query the data bank whether receiving an application for a position on a medical staff team. Once admitted to the medical staff, the healthcare entity must then continue to query the data bank every 2 years concerning each staff member. This act presumes that receipt of information concerning incompetence or misconduct will result in the denial, restriction, or termination of staff privileges. Congress also created a national healthcare fraud and abuse database named the Healthcare Integrity and Protection Databank, the HIPDB. This is part of the Health Insurance Portability and Accountability Act, and the HIPDBA contains reports of final adverse actions taken against healthcare providers, suppliers, or practitioners when liability is admitted or found. The information to be recorded includes the name and tax ID number of the provider, supplier, or practitioner who is subject to the adverse action, the name of any healthcare entity with which the provider, supplier, or practitioner is associated, the nature of the adverse action and whether such action is on appeal, and a description of the acts, omissions, or injuries that form the basis for adverse action. Access to the HIPDB is limited to federal and state governmental agencies and health plans that are required to report adverse actions and to individual providers, suppliers, and practitioners who query about them. Utilization management refers to a combination of plan functions that directs patients in a healthcare facility or setting that includes prudent uses of resources, appropriate treatment management, and early comprehensive discharge planning for continuation of care. The process uses established criteria as specified in the healthcare organization's utilization review plan. The utilization review is the clinical review of the appropriateness of admission and planned use of resources that can be and often is initiated prior to admission and conducted at specific timeframes as defined in an organization's utilization review plan. The review involves the process of comparing pre-established criteria against healthcare services to be provided to the patient to determine whether the care is necessary. To understand how utilization management differs from quality management and risk management, there is a table in your textbook in Chapter 12 entitled Contrast Between Quality Management, Risk Management, and Utilization Review. I encourage everyone to take a look at this table to be able to understand the differences. Efforts at utilization management began in the 1950s and were employed at facilities that had frequent bed shortages as a way to allocate space to patients who demonstrated the greatest need. Utilization management became mandated in 1965 with the passage of the federal law establishing Medicare program. The focus of the legislation at the time was on reducing the patient's length of stay in an effort to control the rising cost of healthcare. During the 1970s, utilization management became a required component of the Joint Commission's accreditation standard, as well as a requirement for participation in the Medicaid reimbursement program. In the 1980s, the Tax Equity and Fiscal Responsibility Act, TEFRA, was enacted. TEFRA established the first Medicare Prospective Payment System, the PPS, which was implemented the following year. Using this PPS, reimbursement was no longer based on a per diem rate, but instead it was based on a predetermined rate based on the discharge diagnosis in relation to the diagnostic-related groups. By the 1990s, the process of determining medical necessity expanded beyond the beneficiaries of Medicare and Medicaid to include the efforts of many managed care and group health insurance plans. Today, their use of evidence-based guidelines is very prominent as it applies to utilization management. Complying with the changing aspects of utilization review has been a challenge for many providers. Case management refers to the ongoing review of patient care in various healthcare settings as it relates to assure the medical necessity of the encounter and the appropriateness of the clinical services that are provided. Case managers are also known as utilization coordinators. They are frequently nurses or health information managers who have responsibility for managing the review process and coordinating a patient's care with providers, nurses, as well as other allied health professionals. In many settings, the case management function is organized into a department and may also include social workers and clerical assistants to help with the communication and coordination of review activities. Utilization management continues to be a physician-centered function, although it is coordinated by case managers. The utilization review process consists of several steps of review. These are listed in your textbook entitled in the figure, Steps in the Utilization Review Process. Now, utilization review process consists of several steps. The steps being pre-admission and admission, concurrent review, discharge planning, and audits and reviews. Each step plays a role in determining medical necessity. During the pre-admission and admission review steps, the case manager uses criteria and screening software. In some cases, they may contact a patient's third-party payer to confirm that the admission is approved. Concurrent review, sometimes referred to as continued stay review, assures that the continued medical necessity and appropriateness of care being delivered to the patient, along with appropriate documentation to support the decisions made concerning necessity and appropriateness. Discharge planning involves coordinating activities for the patient's release from healthcare facility, along with the appropriate documentation of the discharge status in the patient's health record. Case managers work closely with health information managers to conduct various audits and reviews for compliance with the work plan of the Office of Inspector General and the Department of Health and Human Services. At this time, we have completed our discussion of Chapter 12's Risk Management, Quality Management, and Utilization Management. I do encourage everyone to review and read the textbook for this chapter, and please feel free to reach out to me if you have any questions or concerns. Thank you.